Hi, Haran. You want to take off your video, please? Hi, Haran. You want to take off your video, please? Hi, Haran. You want to take off your video, please? Hold on. Okay. I was just muting the Facebook stream. All right. We're live on Facebook.
Are we going live? Huh?
We are live on Facebook already, but I'm just going to give it a few minutes so that we, as I mentioned the last time, so that people, so let the live build up so that people can join us on the live. And then we will get into it. I'm also recording the session.
Oh, I didn't even tell. It's on EOC stream, yeah?
It's on EOC's page, yes.
I forget to tell.
Oh, what type of laugh was that?
It's our family.
You still have some time. You have a few minutes. All right, I'll just give it 1 more minute and we'll start. Good afternoon, Nicholas. Nice to have you with us. All right, Christine. So I think a minute has gone, so let's get into this. Good afternoon, all. Welcome to our second episode in our Facebook Live series. And of course, today we're going to be talking about conciliation and the benefits of conciliation. So I am Shelley Dolabai. I'm the manager of corporate communication at the Equal Opportunity Commission. And I am joined by Christine Cool, who is our conciliator mediator at the EOC. Good afternoon, Joanne. Nice of you to have you with us today. So let's get straight into it, right? So Christine, there are many people who already know what conciliation is, but for those who do not, can you explain what is conciliation?
Shelley and everybody who's tuned in. Conciliation, I like to say conciliation mediation because the terms, the processes are very, very similar. In fact, in the industrial court, they use the term conciliation. I myself have been trained in both conciliation and mediation. They're both forms of alternative dispute resolution. You might say alternative to what? Alternative to going to court. Within recent, I shouldn't say recent, within all our living memory, most disputes that have become intractable have been solved via going to court. You hear people say, I'll take you to court, or I'll see you in court. So this alternative is a philosophy where there is that people who are in disputes, who are in conflict, are the best people to resolve it themselves. So that's the alternative to going to court. That persons who are in dispute have the best knowledge of the facts and can resolve it themselves. So they sit with a conciliator, mediator, and that person is trained to help them work through and have a good dialogue of the process and see how best they can come to a resolution.
Yes, okay. Thank you for that. And why do you think the process of conciliation was built into the Equal Opportunity Act? Why not go directly to court?
Okay, so that is one of the things I really like about the Equal Opportunity Act, as opposed to, of course, my bias because I am a conciliator mediator. It's one of those pieces of legislation in Trinidad that recognizes that people can resolve the issues themselves. Now, it's fairly new legislation. When I say new, it was enacted in 2008. So that's still fairly new. When conciliation, mediation was really becoming, known and becoming as an alternative, a viable alternative. So the thing is with discrimination, the Act provides that there's state categories and status grounds which prohibits people or discourages people from discriminating. But the thing is, sometimes discrimination happens so subtly, or somebody might have been doing it for so long that they don't even recognize that they're doing it. And then, boom, you're faced with, you have to go to court. For my, the way I see the benefits of it being built into the EOA, Equal Opportunity Act, is that a lot of sometimes discriminations happens with employer-employee. And you know what a court battle can do, because that is what it is. It becomes a court battle. When it takes all, somebody wins, somebody loses. At this forum, persons can sit down and have constructive dialogue and realize, listen, I didn't consider this, or I didn't intend this, or I may have reacted rashly, or whatever reason. But it's a forum where they avoid that whole adversarial aspect of going to court. Never mind the money that an ordinary person who feel that they had been subjected to some form of discrimination can be prohibited from even getting the basic form of sitting across from somebody and telling them, listen, this is what happened to me. And they would have had to have a lawyer to go to court to do that. So the conciliation process facilitates that. It allows that you can sit down. You don't need a lawyer this process, so you can sit down and Shelley, you would know sometimes just the mere fact of somebody being able to sit across from that person and tell them what has happened, which we would call venting. It's very healing, for the person. Sometimes you think that's what I wanted to do, but they would not have had the chance before. So the fact that the Equal Opportunity Act has that, it's really very good, because I've seen a lot of people pass through the Equal Opportunity Commission and have gone their way and were quite happy that they were able to resolve it at this forum. Even if not resolving it at this forum, they had such a better understanding of all the facts, well, okay, yes, I really think it was discrimination and I'm going to pursue this, and so they were in a better position to move on.
Yeah. Those are really important points that you made. And one thing stuck out to me from what you said, which is being able to sit across from a table and have a conversation with somebody about it, and it got me thinking, because there might be some people out there who might be in a situation where they may say, okay, I'm an entry-level clerk, and a person who is discriminating against me is a senior member of staff. Like, what can I do? What in a situation like this? Could you offer some advice to that person who might be thinking this way? Would the alleged discriminator or the respondent be absolutely bound to the process of conciliation if that person were to lodge a complaint against them?
Okay, so I'm going to answer this on two levels. The one that the respondent, which would be the alleged discriminator, is bound to come to the process. The philosophy behind mediation and conciliation is that it's a voluntary process. And I do recognize that, because people come in to sit down and talk and have, so they must have some kind of willingness to talk, to come there. So that is key. However, the Equal Opportunity Act, one of the things is that if a respondent does not want to come to conciliation, there are sanctions, just as if they fail to respond to requests from our legal unit for information during the investigation stage, which is the stage, of course, prior to conciliation. If they fail to respond, then they can be taken to court, and they have been taken to court. And there are stiff sanctions, so, and it's the same way. If somebody decides that I'm not going to going to go to conciliation because, sometimes the respondent, the complainant wants to have this conversation for whatever reason they may not be willing to come. There are sanctions. However, the philosophy behind it is that it is a voluntary process. Now, let me answer the second part of your question, or the first part, the second part I answered this. The first part is if an entry-level person brings a complaint against a CEO of a corporation. Well, Shelley, that has happened, because a lot of the time, because the act protects not just employees, but potential employees. So even if you have applied for a position and you've been discriminated against and not even in the organization, you can be discriminated against, and that's in the act. So even if you're, as you say, entry-level employee or low down, I know most will be intimidated, figure, well, that's the boss or whatever, and they might feel intimidated to come here. Part of the job of a conciliator and my job here is that when people sit around that table with me, or now online, and I still consider it around the table, is that everybody is equal in that forum. Everybody is equal. And part of my job is to maintain that. So the person who might be an entry-level person will not be made to feel that, listen, you can be intimidated by your employer or by the CEO or whatever. Human nature being what it is, they will try. And they will try. And as I said, part of my job is to make sure as far as possible that does not happen. It's a process as well that is not attorney driven. So unlike in a court of law where you have the attorney speaking on your behalf or the attorneys for the other side, one of the things we do when a respondent comes, and corporations would always say, well, let our attorney handle it. I try to share, listen, the attorney is welcome, and I welcome them to the process, but you have to speak on your own behalf, on your company's behalf. So all that to say that the playing field, we try really hard to level that playing field so that nobody's disadvantaged.
Yes, this brings up a whole lot of questions in my mind, and I'm certain in viewers' minds as well. So, I would act as that person to get these questions out to you. So I know conciliation is supposed to be a confidential process, right? But beyond confidentiality, what happens if my employer victimizes me or uses my words that I use in conciliation against me in the workspace outside of conciliation? Is there any provisions for that?
Okay. Well, the confidentiality of the process is one of the hallmarks of conciliation. All right, and it's always a very area which I spend a lot of time on to get people to buy, because to answer your question directly, and then I'd want to explain, there are no sanctions for breach of that confidentiality. All right. So what we ask for is what we call gentle person's handshake. They would say gentleman, but I would say gentle person's handshake.
I like that.
We appeal to people's highest sense, and generally, I think, cooperation in that area. We ask people, listen, this is a safe space. You can come here. Describe exactly what has happened to you. But we don't want it going through the company. We do not want it going that, this person went to conciliation and she said this or he said that, or the employee is saying that. So generally, I have had no complaints of people coming back to say, well, this one said this and this in the organization. But again, we have people sign an agreement to participate in the process, and they sign it, and it's explained very, very carefully. So generally, I find most people abide by it. So there's no, they seem to overcome that hurdle of the confidentiality of the process. There was another part of that question I'm thinking I may have missed.
I can't remember, Christine. We'll move on, and I just wanted to say good afternoon to, I hope I'm pronouncing this correct, Jean-Marc, who also joined us. And remember, guys, feel free, if you have any questions that you like answered, you just put them in the comment section, and Christine or myself, we will answer. So conciliation related or not, you can put it in there, and we would respond to your questions as best as we can. Right. Christine, you kept touching on different aspects of conciliation and some things that you might ask people to do while they're in conciliation. So I know each session is different, but could you walk us through what a session might be like, the type of questions you may ask, or the space you try to create? So in other words, what can someone expect if they attend conciliation?
Okay, so the conciliation process begins for me when I meet the parties separately prior to the in-house session, and that session is very, very important for me. It's the first time I'm meeting the parties, the complainant and the respondent. They don't know me; they've never seen me before, but I have to build trust. I have to build some level that they can trust this person who's going to handle this process. Because if there's without trust, they're not going to participate. They're not going to dig in and be committed to the process. So these pre-conciliation meetings are very important. And I would talk with them, explain the process for them, ask them if they have any questions, get a feel of from them what they're looking for, how they see this resolved. We do not discuss all the details of the case at this point, except they want to, so they get an idea. I put them at ease. I try to make it very comfortable so that they are, they're ready for the process. That it's not like a court of law. There's not going to be cross-examination. There's not going to be, rules of evidence and all that kind of thing. I'm not a judge. I don't look like a judge. We're not going to judge anybody. And that's one of the things I try to get to them. We're not here to judge anybody. We're here to have a conversation. This is your opportunity to have this conversation. And Shelley, conflict is something that really has a huge emotional component for it. So no matter what, people are hurting. And especially somebody who feels they've been discriminated against. This person got this job, this promotion instead of me. This person got, I feel that I have, because of my race or whatever. So there's a huge emotional component. And I try to make it as comfortable as possible for them, to let them know, listen, this is the forum where you can talk about that. If this goes to court, that's off the table. Your lead is going to be your attorney, and all the emotional parts is off the table. So I think that I know that appeals to them. I can see the shift one time that they come, okay, so I'm going to get a chance to talk about it. Because at the end of the day, people really want to be talked and listened to. People want it. And I'm always saying, if that had happened way back then we would not have reached there, but we're here, so let's move forward with this. But so the pre-conciliation session is very important. And I have that meeting with both parties, not only the complainant, but also the respondent, because the respondent, never mind that they've been accused of something, now they are just as confused sometimes as the other person. I've been accused of discrimination. I'm not a discriminator, so there's a lot of defensiveness, they try to defend even before they reach the court, and I understand that. So I bring them at ease too, try to talk to them and see, listen, this is a process. Nobody's accusing you of them. We're not here to judge you. Explain what has happened. Maybe there was something that the other person did not know that you have an opportunity to explain. So that's the pre-conciliation meetings. And then, of course, when we get into conciliation, both parties are prepared for the process. They're allowed to have at least two other persons with them who can support them, whether it's a friend, a family, industrial relations expert, an attorney, any support person, and they come and we sit and we have a nice chat around the table. It's structured, so it's not, really, it's very structured, which I would know the structure of it. We go through, we ask this one to talk, we have guidelines of again, confidentiality, of being respectful, how we're going to address each other, so there's very little room for disrespectful language, and yes, there will be occasions when people are hurt and they would need to vent, but even that is kept at, at a respectful level. Because we can't vent without, we can be armed without being, abrasive and disrespectful. So, and the process goes on. The process is about 3 hours. It's always not ever enough, but I respect people's time. Sometimes we've had sessions that go on for longer, a little longer, sometimes a lot longer. And we work through it. The process may not end at the first session. We may have to have another session and another session. But generally, we try to end the process within 3 months from the start of the process. So that's another benefit which I put in right there. It's shorter than court. I mean, if you go into court, you might get a court date for 6 months. You can finish the conciliation process in 3.
There we go. Christine, I have a question for you from the comment section from Joanne. So she asks, in the event that parties arrive at an agreement, will the agreement be legally binding?
Yes, the Equal Opportunity Act speaks to that the agreement, once it's drawn up and signed by both parties, it's registered with the tribunal. The tribunal is a separate body from the Equal Opportunity Commission. Though we born out of the same act, it's a separate body. There's no overlap at all. The overlap is, the only thing is that all the matters that go to the tribunal come from the commission. I thought I'd just say that here. But once the agreement is signed, it's sent up to the tribunal and they register. Once it's registered, it becomes an order of the court. The tribunal has all the powers of a high court in Trinidad and Tobago. And anybody who breaches that agreement can be held in contempt of court.
Yes, thank you, Christine. And thank you, Shirley, as well, who said the session is very informative. I just wanted to add as well, because I mean, it's something that pops up every now and again. And I hope Haran, who was on with us last week, doesn't mind that I take this example from him, but he drew the parallel to the Ministry of Labor and the Industrial Court, when he said the commission functions much like the Ministry of Labor, trying to conciliate matters when it comes to employee relations. And if there is no, if it's not resolved at the ministry, it goes to the Industrial Court, which is an entirely different body to the Ministry of Labor. So I just wanted to stick that in there, because we've been getting a lot of questions and comments and so on, just to make sure we establish that it's 2 separate bodies completely. Right? You're welcome, Joanne. She said thank you very much for your explanation. Christine, so have you ever gotten feedback from persons who attended conciliation? Like, what did they have to say about the session? Were they able to get redress?
Yeah, we've had quite a bit, actually, in terms of people who have had their matter resolved, and people, as I said, whose matter has not been resolved and has gone to tribunal, for adjudication. Generally, persons who come in here who are committed to resolving, they would find some kind of resolution. And even so, sometimes somebody is committed to resolving one party and the other party would be just, we just don't reach a resolution. But generally, they find the process has been helpful. Most part, whether it's resolved or not. And they would say that to me at the session. You've been very helpful, even from the pre-sessions, the pre-conciliation sessions. They have found it to be very, very helpful. Those pre-conciliation sessions, that they are able to be fully prepared for it. So they do find the whole conciliation process. Shelley, when you're able to, I think one of the things that humans, the basic needs of us is autonomy. And for so many of us, we figure that we have lost that, that we cannot make decisions our own. Conciliation offers you that. It gives it back to you. I don't need a court, a judge, to tell me what to do in this case. I can make a decision for myself. I can advocate for myself. I'm not knocking the courts. The courts have a valid role to play in our society. And some of the matters that come before me are best resolved by the court, and they escalate there. But for people who it may have been miscommunication or non-communication or anything like that, they can sit down and resolve the matter themselves. It is so empowering for them that you actually see, oh yeah, I can do this, and they are able to. And for me, that is one of the really good things about conciliation. That people can, you know what's happening. You have to work with these people or live with these people afterwards, and the conciliation teaches you to resolve it in that really empowering atmosphere, that it does not have to be adversarial.
Yes, absolutely. And I think we haven't covered in this session, which we have to close off soon, unfortunately, but we didn't. Yes, we're just under half hour. I think it's really important to note as well that these services are free of charge. The conciliation session that the Equal Opportunity Commission offers, it's free, so it means that it's accessible. So if you're unable to afford legal fees, that there's some sort of redress for you, and you don't have to, pay an arm and leg for the legal fees. So I think that is definitely a huge benefit of conciliation. So Christine, thank you so much for joining us today. It was absolutely amazing having you here. It was very informative. Everything that you were saying, I'm certain people learned so much from you today. And thank you everybody for your questions and for joining us. Before we close off, Christine, is there anything you'd like to add?
Shelley, I thought, oh my God, half an hour is long, but I'm just getting started.
It just flies.
Yeah, conciliation is really, I believe in the philosophy of conciliation for the matters that I've stated before, but I also want to know that people can come up with very creative ways to resolve their disputes. The court, for a large extent, is bound by handing out a monetary settlement. And even for a lot of the matters that come, I have the honor of sitting with the participants. It's not about money, but I always say conflict is something that people want to be heard. People want to know that you matter. And if I speak to you, if I speak to my boss or this person, whoever, and they don't hear, I'm going to shout louder. And then I'm going to shout louder, and I'm going to shout louder. And the loudest shout is at the court. And you find when you reach the court and you've shouted, metaphorically, of course, that you've shouted there, all you're getting is a monetary settlement. It still doesn't ease the pain that you would have felt for what this discrimination has caused. So yeah, you may have money in your pocket, but you're still not satisfied. Mm-hmm. So that is one of the things with conciliation, that you get a chance to be heard.
Yes.
In that process. It's a safe space, and you do get a chance to be heard. Yeah. And even if the other party, I listen to you.
Yeah. Thank you so much, Christine. Also, I believe that before the Equal Opportunity Act existed, that there was no legislation in place that dealt with discrimination. So even if you were to go before the industrial court, it wouldn't be related to discrimination. It would be some other bad employee relations, or I can't remember the term.
Some iteration.
Yeah, some iteration of that, So the act really and truly brought about being able to discuss discrimination the way that you feel. And I would imagine that conciliation would be a huge part of that process.
Yes,
Yes.
conciliation is a huge and vital part of it. Very vital. Yeah.
Thank you so much, Christine. I agree with Joanne. This was a wonderful session indeed. So we will see you all in 2 weeks, right? When we have our next episode of Know Your Rights. So thank you all, and please be safe and take care.
Bye.
Bye.